Very good morning, ladies and gentlemen. Thank you, Mr. Yip, for those kind words of introduction. Don't really deserve any of that. But both you and Richard said that how nice of me to take time off to be here this morning. When Richard called me a few months ago, I said, thank you very much. It gives me an excuse to get out of hearing more lawyers, 10 files a day. So, but anyway, today is not a hearing day for me, so I'm glad to be here. And I think the very idea of Conference of Sports Law, the second one running this year, is absolutely marvelous. This is a niche area of the law. It is something new and developing, and all of us can learn from it. I've heard a lot just now from Mr. Chris Anderson. I think that's an eye-opener. I'm sure I hear more from Paul and from Isa. But I'm going to speak from the judicial perspective. I'm afraid if it's going to be a bit boring. So those of you who have gone through this, you might find it repetitious, but please bear with me. I think majority of people in here are lawyers, so you will know what legal proceedings are like. It's all very humdrum and so on. But let me try to make it a little more interesting for you. What I intend to do is actually very quickly give an overview of the position here in Malaysia. I will be dealing mainly with domestic law rather than international law. We of course will be familiar with the tortious claims and civil liability claims and so on. I want to run through some of the cases. I will review a few cases that have come to court and also talk about alternative dispute resolution, arbitration and mediation. I know time is not really with us. We have 3 speakers, so I'm told we'll each have about half an hour. That will take us till lunchtime, and we don't want to keep you too long. All right, I start with very basic stuff, and that is on a playing field. And this is where disputes start. And you know the rules of the game. And once the decisions are made by the referee, the umpire, that's it. He exercises his discretion. But of course, what is important and what is of important interest to us is what happens after those decisions have been made. Now, to know any sport, it's important, of course, to know the rules of the game. It's the idea is how do we regulate fair play, both amongst players, and sports administrators. Administrative law, the governing sports body, that's a major aspect of what I'm going to talk about. Then, of course, we have to be familiar with the constitution of the sports body, what constitutes the disciplinary tribunal or disciplinary committee, and how they hold their internal hearings, and the fact that the decision will be final. But of course, all this will be subject to the rules of natural justice. Okay, judicial review, that of course will only apply not within private bodies, and not if they are purely contractual. And I will be going a little more into that. We have the examples in international governing bodies, example FIFA, and as you well know, they govern the sports through various statutes, rules, regulations, standing orders, and law of the game. English common law, whether that applies still to us, and we have sections 3 and 5 of the Civil Law Act, the applicability of the civil law. Only very recently, a decision was delivered in the Court of Appeal, and nothing to do with sports, but it concerned the case of orang asli rights, native rights. A case, this is a Yibet binti Saman, orang asli case, and the whole question of whether, in view of the Aboriginal Peoples Act, whether common law still applied. And the court held, yes, we still have the sections 3 and 5 of the Civil Law Act, and we still can apply common law principles. here in Malaysia. A few statutes which are of relevance to this topic. We have the Merdeka Corporation, 1957, and I think, as you know, this is purely, mainly to manage the Merdeka Stadium. Then, of course, importantly, we have the National Sports Council of Malaysia, 1971, and the Sports Development Act of 1997. This act, SDA, is important because it regulates sports administration in Malaysia, and all sports bodies must register with the SDA in order to carry out the activities. A little more on the SDA. Important person here, of course, is the Commissioner of Sports, Section 10, and he has a power to register or refuse to register any association, club, society, or company as a sports body, and impose conditions, and of course he can revoke or suspend registration. Now, importantly, a aggrieved party may appeal to the Minister of Youth and Sport within 30 days of notification of a decision by the Sports Commissioner. And then, of course, the Ministry may refer the dispute to a Sports Advisory Panel for advice. And under Section 23, that's the internal procedure that applies, which some will see it as speedy, certain, and final. And what is not resolved there, then of course will end up in court. I have just noted at the bottom there, which says problem of excessive violence, whether this is to be dealt with internally or under the criminal law. Then, of course, as you know as lawyers, generally, of course, what was the intention and how was this violence caused? Section 27 provides for the establishment of the Sports Advisory Panel, which I've just referred to, and this panel is to advise the Minister on all the sports matters. Comprises of a chairman and 8 members. Section 24 allows the aggrieved party to refer a dispute to the Minister for resolution. What are the types of disputes? Mainly, this will be disputes between sportspersons and sportspersons, between sportsperson and coaches, between coaches and officials, between sportspersons and officials. What about the difficulties faced by the sportspersons? Now, one of the main problems in internal hearing will be not being able to be represented at the hearing, or notification of the hearing is short, lack of transparency, and decisions made even without hearing or without the opportunity to appeal, and what may appear to be an arbitrary use of authority. Definition of dispute. Well, this would simply mean any argument, any controversy, and as we often find, usually settled before a domestic tribunal which exercises jurisdiction over internal affairs of the body concerned, and is generally governed by principles of administrative law. And disputes between the sports bodies and disputes between within the sports bodies and between sports bodies are often major areas of dispute. The question often asked is whether a sports body, in view of the expert knowledge it may have, whether they can adjudicate a dispute better than a court of law. Well, I think the jury is still out on this. It's very much whom you are talking to and what is it that you wish to hope to expect. But of course, the main issues that will always arise in any resolution of a dispute will be issues of natural justice and fairness. I think Richard Weng mentioned this right at the beginning, and it's absolutely right, because when you take part in a game, you really want to have fairness, and there's absolutely no room for anything else. It doesn't matter whether you belong to a particular religion or whether you're from a different race. Everybody wants to have the same rules to apply and to achieve fair play. So in any dispute resolution, there must be fairness, and there must be procedural fairness, proper right of hearing, and to apply the rule against bias. There cannot be any conflict situations arising. Litigation in court. Now, a very quick word. As you all know, the High Court exercises supervisory jurisdiction over jurisdiction and proceedings of inferior courts, of tribunals, bodies of persons carrying out quasi-judicial functions, and persons who perform public act and duties. Right? This is the general jurisdictional power of the court. But then importantly, the question that you ask is that for it to come up to court for judicial review, for example, what is a test? Does it mean to say all cases can come up for JR before the court? The answer would be, the test is whether the body is subject to judicial review is the source of its power, i.e. from either statute, whether it's a prerogative right, and not purely contractual. As I mentioned just now, if it's purely contractual, the JR is not a mode that you can refer to. Let me illustrate with a few cases. A very interesting case. Law against National Greyhound Racing Club Limited, 1983. Here, this is greyhound racing. I think those of you who have studied in UK will know that this is a very popular sport. Stewards of the club found a dog had failed a dope test. So now, don't give up. Don't lose heart if any of you have failed a dope test. Even animals go through dope tests. And of course, not the dog was not suspended, but the trainer was suspended. His license was suspended for 6 months. And it was held in this case that the powers of steward were derived from contract between the owners, trainers, and the club. And this case was outside the scope of judicial review. And certiorari could not be granted by the court. The court will only review the procedural aspects when arriving at a decision. I think this is again quite trite in administrative law. In judicial review, the court is not an appeals court of a decision made by any authority. It is merely to consider whether the procedural aspects have been complied with. It will not review the findings or decisions of the disciplinary committee. All right, so that is very important. This is what's stated in Halsbury's Laws of England, that usually the court will not allow where there's an alternative remedy by way of appeal. However, GR may be allowed where the alternative statutory remedy is nowhere near so convenient, beneficial, or effectual. Example, where the decision was made without jurisdiction or in consequence of an error of law. Arbitration, I'm going to run through this because I want to mention a lot more about this later. But in Malaysia, the FAM is the only national sports body, I stand corrected, but as far as I know, that's the only sports body that allows members, associate members or sports persons in its dispute to appoint its own arbitrator. Some recent cases here in Malaysia, some common problems which have been addressed. The case of Chin Mi Kiong and others against the Commissioner for Sports. This was an Order 15 case, and this concerned the Malaysian Taekwondo Association. The question was whether the association could sue in its own name, and the court held that the association cannot sue in its own name. It should be commenced by a public officer, the registered public officer, and if there is no public officer, then an office bearer of the association claiming for and on behalf of its members. But importantly, Order 53 must be complied with, and that is, whoever is applying for GR must be a person or a body of persons adversely affected by the decision of the public authority. And generally, the rule is that judicial review, GR, is not available where there is an alternative remedy by way of an appeal. But I'll come to another case later where that may not necessarily be the situation today. And a test, of course, is whether the application for leave is frivolous to merit the refusal of leave in limine. The fact that an arbiter must be fair and impartial is given, and at the leave stage, leave for GR, the threshold is fairly low. The court is only to consider whether there's an arguable case in favor of granting an order of, for example, certiorari. And the general rule is that JR is not open where there's alternative remedy. In Anamalai against Party Supaya, this is a 2009 decision by Justice R.F. Yusof. This was a Persatuan Bola Sepak India Malaysia case. This is the Indian Football Association of Malaysia. I didn't realize there's such an association, but obviously there is, and there are disputes. And this case, the dispute went on for a very long time. And by the time it came up for hearing, personalities had changed, and that was very important as far as the decision was concerned. But this was a matter where the plaintiffs could have referred the matter to the sports commissioner to refer, who could then refer the matter to the minister, and also whether the Section 24(3) would apply. It was held by Justice Arif in dealing with declaratory orders. A declaratory order being a discretionary relief to have acceded to the plaintiff's application would have resulted in an intricate unraveling of the affairs of the association, which in itself would have been inordinately prejudicial to the association. This is more of a policy statement. But importantly, the judge found that the personalities involved at the outset of the dispute had changed, and in this sense, the personal dispute between the parties had been spent. So the court was not then going to be dragged in for something which was purely a dispute between individuals. The issue had become too radical, and the court was not in a position to provide any practical guidance, such that it was not proper to grant the orders sought. It's a well-accepted general principle of much utility and practical sense that members should first attempt to resolve the dispute internally. I think this has been said many a times, that you must exhaust all your internal remedies, internal processes before coming to the court. I suppose this is one way of hearing less cases, but basically you want to have this in compliance. You want to follow what is allowed within your own setup, your constitution, your domestic inquiries, and so on. So the principle of the exhaustion of domestic remedies was recognized in numerous cases, and this goes back a long way. Since 1961, Kamalingam, a footballer, Dollah bin Saleh, the 1989 case. The Sports Development Act, the XDA, provided the governing statute framework in this case, and the judge held that Section 24 was broad enough to have allowed a referral to be made to the minister to resolve the dispute, and he also held that relief should not be granted where there existed a suitable alternative procedure. Sorry, I'm missing a page.